word. Okay, when the judge tells you to be quiet, you be quiet. Whether you're a lawyer, whether you're a defendant, whether you're someone sitting in the gallery. Judge says be quiet, you listen. That's the rules of the road. Welcome back to CourtTV Live. Court is in a recess. Let me bring in my guest to talk about that cringe-worthy moment. Criminal defense attorney Reggie Lewis still with us, and joining the conversation, former prosecutor and criminal defense attorney Marcia Mignon. So happy that you're both here. That was horrible, I thought, for the defense. Marcia.
Horrible idea. You never want to become combative with the court. You always want to remain calm because the jurors are watching your conduct. And it's also indicative conduct of what the prosecutor is saying you're capable of doing.
And he almost kind of gave a dirty look to the judge. It was really upsetting.
It looked like he forgot where he was at.
Yes.
And I would think that may be something you'd see if you're incarcerated, a response to a correction officer, not a judge.
And by the way, he's gone through this before. Remember, this is a retrial. Okay, so something big happened a little while ago this afternoon, and that was one witness that was supposed to testify. We just want to catch up the viewers on this. Gregory Washington, Gregory Washington was set to testify. He was brought into the courtroom. He looked like he was incarcerated. Now, he was supposed to testify that his two friends, Demario Paramore and Hayward Griffin, are responsible for the murders of Brandy Peters and her children. So he walked into the courtroom, and then he said this.
Mr. Washington, can you please spell both your first and last name?
I'm not testifying.
State your name, please, sir.
Gregory Washington, but I'm not testifying.
Ask him a question.
Mr. Washington, back in 2010, at some point, did you have a criminal offense pending?
I'm not testifying.
So why did that happen? Okay, Gregory Washington, he worked with the Tallahassee Police Department back in 2010 as a confidential informant, and he was supposed to come in and testify about a recording he made while wired, and that recording is supposed to be a confession from Demario Paramore, one of the alleged murderers, and we do believe that though Demario Paramore and Hayward Griffin are responsible for the murders. That's the defense's story, and they were instructed to do so by James Carlos Santos. Okay, so why did that happen? I'm going to talk about it with my guests because we've been through similar things like this. This is not surprising to me. And my first thought is he is scared. Someone is threatening him. I want to put this more context is that James Carlos Santos was transferred from federal prison to the Leon County Jail. Washington may have been in the Leon County Jail. These guys, Paramore and Griffin, they may be there too. And this has happened to me before where, you know, your client crossed paths with a witness or somebody in the jail before a trial, and then everybody freaks out and nobody wants to testify.
It's dangerous. Remember, you are sometimes not protected necessarily by the guards that are supposed to be watching you. And even if you're not harmed by the individual, they can arrange for you to be harmed by other individuals that are in cells that are next to yours. So your safety is at risk.
Reggie, what do you think happened with Mr. Washington? Because he, to me, did he look scared to you?
I think you used the word freak out. This seems like textbook freak out. Remember, this guy voluntarily wore a wire.
Yeah, I feel so bad for him.
He previously testified. And for him to show up today, and it was very clear that he wasn't going to cooperate in any way, something happened. And it makes sense that that something could have happened during that transport or while he's being held.
Because there's so many times I've heard, it's from my clients or other witnesses where they're on the bus and something happens, or they're in the jail or something happens, or they're in the holding. So most courthouses have a holding area, right? There's a holding area for witnesses and defendants, while they're waiting to come to court. So in between the jail, there's the holding area in the courthouse before they come to the courtroom, and everyone's just sitting there. It's just like a big room. So who knows what could have happened even in that circumstance. Now, a lot of people are asking, can he be forced to testify?
He cannot. He has a Fifth Amendment right to remain silent, just like any other witness does. So he can say, Your Honor, I'm going to invoke my Fifth Amendment right to remain silent.
Well, he didn't say that, Reggie.
Right. He said he wasn't testifying at all.
Yeah.
And I think we discussed this, thankfully for the defense, that there's prior testimony. And I think they're going to, or the judge may allow that prior testimony to come in from the previous.
Sure. Yeah. Okay. But first, before we get there, is there anything you can do to him? Can a judge order him to testify? Can they order him to speak?
I've never seen that. I've never seen the court have the authority to say you're going to have to testify.
Could he be held in contempt or anything like that?
Well, he's already in custody. What are you going to do? Put him back in custody?
Exactly. So you can't just add on charges. And okay, so he doesn't testify, but luckily now, because, and just talking about evidence, since he says I'm not going to testify, then he becomes what's called an unavailable witness. If he's an unavailable witness, is that the predicate to allowing the prior testimony to come in, Reggie?
Well, that appears following his testimony, or if you want to call it testimony, the judge made a statement that they can look into the video of his previous testimony. So it appears that the judge may allow that in to establish his testimony, being that he's unavailable.
Okay, we're going to go out to the courthouse. Chanley Painter is there. Chanley, a very tumultuous afternoon there in the courtroom. Fill us in on what was happening with Gregory
Carlos
Washington.
Santos, here we hear his name again. Now let's update you all on this. You may have heard earlier, we had thought he was going to be the first defense witness today. However, my understanding is the judge said, listen, that's going to take some time. So rather, he will be called by the defense tomorrow, perhaps first thing in the morning, we don't know. There you have a picture of him. Now remember, Carlos Santos is the one who has written letters and said, this was a mob hit that I ordered. This defendant did not do these killings. Now, take that, Marcia, if you would, in conjunction with this neighbor who just testified. Listen, the victim was nervous because of a letter that she'd gotten from Santos. To me, I almost feel like it's more than reasonable doubt. I feel like, why are they in fact prosecuting Henry in this case? Because I just don't see it. What are your thoughts?
Well, a lot of times when you're prosecuting a case and you absolutely believe that the defendant is guilty of what you're charging him with, it's difficult to get an objective mind. You've looked at so much evidence, you've spoken with your investigators, so you're kind of being tunneled or corralled into a particular direction, and sometimes it's difficult to change course. So that's probably why the state is going forward, despite the evidence that's coming in that's saying, hey, this guy might not have done it. One of the other critical issues is that Mr. Segura has been in custody for such a long period of time. So now, where's your exposure civilly?
Well, that's a really great point. We've talked about that some. He's 8 years, almost 9 years in jail for these charges. So let me ask you, as a former prosecutor, what is the line? How do you weigh the evidence to say, yeah, I think there's enough to go to trial versus, I know you talked about earlier, prosecutorial misconduct, maybe we don't have enough evidence. How do you distinguish that line?
Well, you have to get to the mindset where you're looking for the truth. Prosecutors, as we were trained, are supposed to be truth seekers, not conviction seekers. And every now and then you can get derailed into just thinking, if I think he's guilty, I got to prove he's guilty. And that causes you not to be able to step back and say, wait 1 second, but the evidence is starting to take me in a different direction. There comes a time, though, when you have to step up and say, we were wrong.
Well, this is an interesting case, and the thing I want to turn our attention to now is, what did the defendant say in this case? Remember, he testified today. What did he say about whether or not there was some reason he might have killed this family? Let's listen.
I told the world I didn't commit these murders.
Okay. Why wouldn't you?
You say, why wouldn't I?
Right.
Because I have no reason whatsoever to kill my son or those twins. Neither Brandy.
So you just have no reason to do it?
No reason whatsoever. I wouldn't. What would I kill a child for?
Okay.
Let alone children.
Can't argue with that. Marcia, what do you think about that piece of testimony by the defendant himself today on the stand?
That is fantastic testimony. That is critical testimony. Jurors are looking at his eyes. They're looking at his body language. They're trying to find what is the motive behind such a gruesome killing. And what he's done is explained. I don't have a motive.
And he has consistently said, not only does he not have a motive, but the other part of what he kept saying that I just wanted to make a note of, and I wrote down all my notes today from the testimony, is, listen, you know what? Yeah, I owed back child support, but so what? We were kind of good with that. We were working through that. We were talking through that. And I didn't want my wife to know I was cheating. That's why I wasn't honest with the police. Plausible or not?
Plausible. If we were to convict men across this country for lying to their wives about extramarital affairs, we would not have jail cells big enough to hold them. Yeah. So you've got to think about that testimony. Also, he testified, I was able to work under the table. I was like a contractor and I was working from state to state. So I was able to even guise some of my income from child support services because it wasn't coming from the same state that my child support case existed.
Yeah, completely agree. All right, stay tuned. We're going to have to take a short break, but we will come back on the other side and continue to discuss this case. A lot of things happen today. You're not going to want to miss it. We'll be right back on the other side. Still with me to break this down, former prosecutor and criminal defense attorney Marsha Mignon. Was he credible? I mean, he did get testy. He got angry and he didn't want to be quiet and he didn't like the judge pointing at him. Credible or not?
I believe he was still credible. There was a slip up when he became aggressive with the court, and you want to be careful of that. You don't want to lose your jurors. You were doing fantastic on direct examination. So far, your cross-examination has not gained anything that is critical that would prove the state's case beyond a reasonable doubt that you killed these 4 people. He was also credible when he was able to explain on cross-examination, I had the same type of relationship with my other baby mama, and I did not kill her.
That was a perfect response.
It was
like, my gosh, you couldn't have said a better line. Sorry to interrupt, but that was one that stood out to me.
Yeah, it was just, and when she is honing in on, you didn't know the number by heart, you didn't know the number by heart. I mean, we joke nowadays about how the cell phone is taking away our memories. If somebody goes to jail, they're like, hold on, let me write my cell phone number down because I don't remember it, because we're using the programming of the cell phones. So it's not unusual for you not to know the number by heart. And what she was trying to hone in on is, you're not being honest, you're not being credible. But that's credible because most people think, I don't remember what the phone number is.
Yeah, I don't remember my kids' numbers. That's embarrassing to admit, but it's true. So I think he redeemed himself, and I almost felt like he reacted to the judge. He's been in jail for more than 8 years, Marsha. I just think that he may not have the temperament to always sit and listen, although with a judge you have to, right? You cannot do that. But in spite of that, I felt like he kind of then finally caught himself, rechanneled himself, and redeemed himself. What do you think?
I agree. Even when the judge said, do you realize it? Do you understand? And he responded to the court by, I understand. And you could see his demeanor come back into himself as if this is not the jail cell, this is not the holding cell, this is not the guard, this is actually the judge.
And one could argue after that many years in jail, you're going to be hardened even if you didn't do it. Now, here's the bottom line. I felt like the prosecution and cross-examination and the defense by having him testify, honestly, I did not see any connections made to say he murdered this family of 4. I felt like it showed he is a liar and it showed that he's had extramarital affairs. But did you hear anything to make you say, I think he actually killed all 4 of these victims?
There's nothing. In fact, all the evidence that has been presented so far to the jurors has been evidence as to why the state's motive does not meet pass mustard. If you think about it, $20,000 in child support is not enough to wipe out your child, the child's mother, and then 2 children that you're not even paying child support for. So what would be the motive to murder the twins? Wouldn't you wait until you're making exchange arrangements between Brandy and yourself to take your son for visitation or something like that? It doesn't make sense so far, and the state has not met their burden.
I completely agree with you, Marsha Mignon. Thank you so much for being with us.
Thank you.
Ahead, more of Henry Segura's testimony, including the effort by his defense attorney to explain his client's frustration on the stand.